front. And then we'll few more seconds, then we'll make a start. How are we doing, Georgia? Have we got more to come, or?
They're slowly coming in now.
Okay.
So I think we can start.
Let's leave it another 20 seconds. Let's see what we got. Right, okay, we've got 25. Let's make a start because we've only got the hour, so we can go over a little bit, I'm sure. Right, a very, very good morning to you all. A very warm welcome to the Employment and Immigration Update and looking ahead to 2022 with VWV. Before we actually get into the webinar, if I can just say, you've probably already noticed that the webinar is being recorded. The slides from both our speakers will be shared after the event. And once our colleagues from VWV have finished speaking, there will be questions and answers, and we hope we have plenty of questions and answers on these very important subjects. If you just put it into the chat, please, and I'll read them out and maybe introduce one of you, some of you, to actually ask your question as well of Rebecca and Tom. I'll just introduce our speakers first, and then we'd like to take a picture of the screen if we may after that, but I'll come on to that in a second. So our speakers today, Rebecca Fox, who is a partner in the employment team of VWV. She provides advice on all aspects of employment law, including advising and drafting employment contracts and HR policies, advising on employer and employee disputes relating to unfair dismissal, including settlement agreements and all forms of discrimination and redundancy management. And Tom Brett Young is specialist in immigration law, advising on the full range of immigration issues with a particular focus on advising employers across all sectors. So that's the introduction. So we'll bring them in immediately after this, but we have been asked whether everyone, if we can take a screenshot. Georgia, you're in charge of this, I think. Do you want to come in direct?
Yeah. So if you don't want to be included, then please do turn off your camera. But I'll count to 3 and we can take a picture. 1, 2, 3. And then we'll just do a second one as well. And 1, 2, 3. Okay, perfect. We're good to go.
Lovely. Should be professional, Georgia. That's great. Thanks so much indeed. And on that note, without any further ado, let's hand over to Rebecca, please.
Hello, everyone. Good morning. Welcome to the Employment and Immigration Law Update. So I am going to speak to you this morning about employment, an employment update. And on the next slide, I'll just run through the agenda for this morning, which is that I'm going to talk about returning to the workplace, so all the issues around that, including health and safety obligations. And then I'm going to talk about the employee vaccination status, talking about whether it's a reasonable management instruction to ask somebody to get vaccinated, and talk about unfair dismissal and health and safety concerns regarding vaccination status as well. And then I am going to look at what's coming up in 2022, or what's in the pledges that the government have made at the moment. So these are things that are not related to COVID, which will be a nice breath of fresh air that we're not talking about coronavirus. And then I will pass over to Tom, Tom is going to give an immigration update, talking about changes to the immigration categories for workers, so the skilled worker route and other immigration routes, and the right to work checks post-Brexit. And he is also going to give an update on what's on the horizon and coming up in the next year or so. So let's turn to employment and returning to the workplace. And the first question on the next slide is actually, can I make an employee return to the office? Can we actually make them come in? And would it be a breach of contract to state that the place of work is in the office? Then a company is well within their rights to ask employees to return to the office. But that comes with a huge caveat of the knock-on effects of forcing staff to come into the office full time. It's important to note that Downing Street has confirmed that the government is considering legislating to make working from home the default position. And I'm going to cover flexible working and what's coming up with flexible working a bit later on, by giving the employers the right to request it as the default position. And that's something that the task force in the government are looking at the moment. It's also really important to consider that actually a lot of people have asked staff to work from home for a really long period of time, and it's become the norm, and it's likely that therefore you're going to receive flexible working requests or people who are going to be less keen to come into the office, and you're going to potentially struggle to defend those flexible working requests if it has been working with no issue for the last 18, 19, 20 months. Ideally, what we always recommend is discussing your approach with staff, why you're looking for people to return to the office, what a phased return to the office looks like, and at the same time saying to staff that you respect the working environment they've become used to over the last 20 months or so, but giving them the reasons for the return to the office. And then once they do return, what does a COVID-19 safe office look like? Well, a recent survey showed that 68% of staff are worried that they're going to contract COVID at work, or in the getting to work, so on their commute. And essentially the best way to get around that is to let staff know what safety measures you're putting in place to keep them safe. So wearing masks, social distancing, keeping those offices ventilated, and listening to their concerns, allowing them to work remotely if that works for the role that they're in, and ensuring that all your risk assessments are up to date and COVID compliant. Again, we're going to cover risk assessments in a moment. Signpost those documents, let them know where they can find those risk assessments, let them know what you're doing, how you're doing it, make the hand washing facilities visible, so that they can see exactly what it is that you're expecting them to do and what you're providing. Prepare for every eventuality is probably the best advice we can give at this stage. Also, that a full return to the office may never happen. Recommending tools to keep productivity, communication up, so that you can make sure that should we be asked, and it's something that the government are looking at the moment, to be working from home again, or recommending that we're working at home again due to the rise in cases, that you continue to be able to work effectively, or your staff can work effectively remotely. Keep an open dialogue. Keeping in COVID-19 safe offices is all about not having a one-size-fits-all approach. It also means you're reducing the number of staff in the office should an outbreak occur, and keeping up to date and in contact with staff to make sure they know that you can have non-work related catch-ups or unplanned drop-ins, which will have effective communication with staff when working from home. And essentially it's going to differ from workplace to workplace and from time to time. So it may be that it is more appropriate for staff to be working at home now, but as we see an increase in the numbers, it may be that you then relook and you address that risk assessment again. So what does the future look like in terms of working from home? So already, as you'll see on the next slide, employers have shifted to a remote or hybrid for long term. They've already said this is what our plan is, and they've communicated to staff. And although, as I was saying before, that staff had no automatic right to work from home at the moment, that may change, and they do at the moment have rights in relation to flexible working, and that is that all staff all employees who have worked for 26 weeks or more have the right to make one flexible working request in a 12-month period. And as an employer, obligations here are to reasonably consider those requests, and you can only refuse those requests for one of 8 reasons. I'll run through those 8 reasons fairly swiftly now. But if anybody has any questions about them, feel free to email me later on, because these used to be the reasons that every employer would say no to a flexible working request. So a flexible working request would come in, and we'd work out which one of these, if the answer was we don't want there to be any flexible working because it doesn't work for the business, we're trying to work it out from one of these 8 reasons. So that's the burden of additional costs. Is it going to cost too much that the company cannot afford to do this? It makes it's disproportionate from a cost perspective. Detrimental effect on the ability to meet customer demand, so actually how you then are perceived by your customers, an inability to reorganize work among the other employees, an inability to recruit additional employees. So if the flexible working request was to, say, work 3 days a week and you couldn't recruit for those extra additional 2 days, then that would be a reason. It is a reason. A detrimental effect on quality of the work that's being provided by the staff, a detrimental effect on performance, so the job just isn't getting done or not done to the standard required, insufficient work times, work at the times that the employee proposes to work. So somebody's manning the phones and they're suggesting that they work between the hours of 7 a.m. and 9, and then from 3 until 8, but they're working in an industry where people are only available between 9 and 5, and so they're not going to be able to do the work that they're employed to do. So that doesn't make sense, and is a good reason why you'd be able to refuse. And then planned structural changes in relation to that workforce. Now, those 8 reasons have always been a good reason to refuse those flexible working requests. But the issue now is that staff have been working at home, often without issue, for such a long period of time that staff are going to find it, the employers are going to find it very, very difficult now to refuse those flexible working requests without sufficiently good reason. That hasn't come up in the last 18 months or so. Also on this slide, just flagging that discrimination risk. So women are more likely than men to ask for flexible working requests due to childcare responsibilities, just to make sure that we don't have any indirect sex discrimination claims there, unless that treatment can be objectively justified. So can you justify the reason why you are refusing that application? And also to bear in mind that those employees with a disability are covered by the Equality Act, and there is a duty to make reasonable adjustments. Flexible working is a reasonable adjustment, and if that's being requested because somebody has a disability, there's likely to be a claim if that is refused. So someone's just popped up, is there a slide listing those 8 reasons? I don't have a slide on this deck, but I absolutely can send you those 8 reasons. So if you send me an email, my details will be on the end of this pack, so I will send them over to you. And then we have to start looking at health and safety. So all employers have a legal duty, as far as and the legal terms are as far as reasonably practicable, the health, safety, and welfare of all their staff. So the duty arises in relation to information, instruction, training, supervision, and extends to the risks arising from these duties that are set out on this slide. So the nature of the work, how the employer conducts its business, any supervision, training, instructions, or indeed lack thereof, plant, equipment, materials and substances, conditions and provision of welfare facilities. In addition to these duties, there are also various regulations imposed on specific parts of the workforce, and so including but not limited to those under the age of 18, so young people, women of childbearing age, pregnant women, and also new mothers as well. Also, if you are occupying premises, some have given up premises during the pandemic, but those who are still occupying premises, there is a statutory duty to ensure the safety of all employees and visitors that come onto their site. So the next slide we're going to be looking at practical health and safety tips. So first of all is risk assessment. I've already mentioned risk assessment to you. Should everybody all employers carry out a risk assessment? The short answer is absolutely yes. And it is the best way to effectively communicate to staff that you've considered what all the issues are, and that you are you've identified them, and that you are looking at any hazards that there might be, you're assessing the risk, and then you're looking to eliminate or control. It would be great if we could eliminate coronavirus, but we can't, but we can control that risk, and the best, to make it the best situation for the staff that are coming into the office. Refresh health and safety training for staff, and also any policies as well. Do you need to consult with staff? Well, if you are dealing with health and safety, then yes, absolutely. And the best way to do with this is just communication with staff. So you can do that directly with staff, unless you're unionised, and then that should be with the union. And also, if you're not, there's no recognised union, but staff recognise a staff body you consult with, then you can consult with them about the changes that you're making and why you're doing it and how you're doing it, what that looks like in terms of day to day. Do you have a duty to eliminate all risk? Again, it would be lovely if we could do that, but we can't. But again, it's what is reasonably practicable in those circumstances. A balancing act, essentially, and you take into account the degree of the risk in the particular workplace, and then together with that, the time, trouble, cost, physical difficulty that you might have in taking measures to reduce that risk. And that essentially would all be set out in a well thought out risk assessment. And one of the main reasons I'm telling clients to go ahead and do those is, yes, we want to make sure that we know what the potential risks are by talking to staff, by sorting out what's in the office, but also it's the best defence if there's any prosecution or if there's any litigation or employment tribunal claim, that you've done everything that you reasonably could have done as an employer to make sure that you've made it COVID safe. So then we look at additional steps. What else can you be doing? Hygiene, obviously really important. Everyone's become so aware of it over the last couple of years. Keeping your workplace clean, constant hand washing, it reduces the risk of the spread of the virus. Critical part of making that workplace safer. Ventilation, air conditioning helps reduce the spread of the virus, and simple steps to improve that ventilation. Talk to workers, keep that communication going. I mean, for those who have dealt with me in the past, I am a firm believer that most problems can be sorted, and not many lawyers will say this, by communication, but if you talk about it right at the beginning, work out what the problems are. We're going to get onto vaccination in a moment. It's the classic example of talk to staff, work out what's going on, and explain to them why you're doing what you're doing in the office, and making it safe for them to manage the risk in the workplace as best as you can, and communicate with those working from home, make sure those in the office, and those working from home, as well as those who are remote working in the office, that you're communicating with them both in exactly the same way, and then ensuring that you consider the risk to workers who are particularly vulnerable to COVID, and put controls in place to reduce that risk for those individuals. So now we're going to go on and look at the vaccination requirement, and in terms of vaccination status, what can we do? Well, essentially ACAS are telling us that we are to support, encourage staff to get vaccinated, for example, offering paid time off for going to get the vaccine, but at the moment it's not mandatory unless you're working in the care home sector, and it cannot be enforced without consent, otherwise it's likely you will have somebody knocking at your door accusing you of assault or battery. So it is unlawful to demand that somebody gets the vaccine, but it's a strong encouragement. And Public Health England are basically saying that that employers play such a vital role in promoting vaccination, and urges obviously employers to encourage those employees to get vaccinated. And there's lots of toolkits on the PHE's website, and what they're saying is to have experts and community leaders, so these sort of departmental champions, to encourage staff within the workplace to be vaccinated, and again being open to providing the support. And I found the most problems that have arisen have been due to issues that have been able to be talked about, to understand the fears of those who are saying they don't want to be vaccinated. Sometimes it comes from other colleagues, sitting as a one-to-one to be talking to those individuals to keep that communication going. And then also amending policies, making sure that somebody is not going to, if somebody gets sick because they've had the vaccine, that and you usually pay SSP, for example, maybe to look at considering paying full sick pay, just having a look at what your policies say. You don't want to disincentivize those who are looking to get the vaccine if they haven't already got it. ACAS guidance is again very much the same as Public Health England, and essentially saying listening to concerns, but it's also it could be considered a reasonable instruction to go and be vaccinated. Is it a question of, are we going to be able to take disciplinary action? It's not yet been tested. The suggestion actually is that obviously each case on its own facts, but talk with the staff. Any decision should be put in writing, set out in policies, and already within your existing disciplinary and grievances policies. We don't want to be changing those policies, essentially, if you are going to be changing it, get legal advice before you do look at that, or introducing a vaccine policy. It is probably safer, rather than going down that disciplinary route, that looking at if somebody is not vaccinated, how then you keep the rest of your staff safe. And then if on the next slide, I think actually it's asking staff about vaccine status, you must have a good reason to ask for it. That will be the health and safety of your other staff. That's your good reason. It's sensitive personal health data, and therefore you need to comply with data protection rules here. The ICO advice is fairly clear in this area, and that you can ask staff, or should be asking, rather than insisting that they tell you about it, and because it essentially is less likely to lead to an ICO complaint, ICO being the Information Commissioner's Office, and that they are more likely to volunteer this information if you don't insist on receiving it. Essentially saying that there has to be good reason to collect that information, and that you may face difficulty if an employee does refuse it. And if you want to collect information, there has to be that legal basis. The safest at the moment is compliance with your legal obligations, so substantial public interest basis, preventing the spread of the virus and complying with your duty of care to other employees that we spoke about right at the beginning will be the root of your justification, rather than customer or staff preference of somebody else in the office wanting to know whether somebody's vaccinated. Probably isn't going to cut it in terms of a defence for it. If staff refuse and they don't want to tell you, problems obviously can arise. Again, asking about vaccination status, is it a reasonable management instruction? Probably yes, and then you can go ahead to discipline employees if they refuse to answer. But again, always take advice on specific situations, because it's a really grey area, and different opinions on this, and taking disciplinary action against those who haven't been immunised has not yet happened, and so there's no certainty on how that will go. Each case again will depend on its own facts, and you have to be able to justify asking whether vaccination has taken place against the risk of what might happen when you do so, and the risk of claims, and also the risk of then those who are not vaccinated passing that on to other people that they're in contact with. the government previously announced that COVID status vaccine certification would not be legally required as a condition of entry for visitors to any setting, but they would encourage and support those businesses and large events to use this NHS COVID pass in high-risk settings. And it said if sufficient measures were not taken, then they would look at that COVID pass, but actually they have already announced that the COVID passports are not going to go ahead, and that it's, as you all know, it's only needed at the moment for overseas travel. On the next slide, recruitment, can we ask during the recruitment process, I mean, you're on really dodgy ground if you're asking potential new recruits whether or not they're vaccinated. It's sensitive data and would be deemed inappropriate to be asking in an interview setting because they're health related questions. Section 60 of the Equality Act covers this point. It's the general position it's unlawful to ask questions in relation to health during an application process, and you're opening yourself up to a potential claim there if you do ask. Limited exceptions where such a question relates to the candidate's ability to carry out a function, so it's essential to the job. So obviously if you're recruiting into the care home industry, then you are allowed to ask for that. On the next slide, we're looking at what is on the horizon. So what's next? And I'm eating heavily into Tom's time, so I'm going to whistle stop tour through these ones. So sexual harassment in the workplace. There was a consultation in 2019 regarding sexual harassment in the workplace, because during that consultation, what came out is that a large number of mainly women felt like they had been sexually harassed in the workplace, and the government have pledged that they are now going to do something about that, and that they're going to look at the law in this area. What they're doing is looking at this prescriptive duties on employers to prevent sexual harassment in the workplace. What they're doing is making a positive duty on employers to prevent sexual harassment in the workplace. So that there doesn't actually what they're looking at is there not actually having been an incident of sexual harassment for there to be a claim. So if your training is not compliant, up to date, or that there's no zero tolerance, or the policies are not up to date, and dealing with this issue, then it's likely that you're going to come under heavy criticism. So that consultation ended. The proposals have just been announced, and again, the main proposal here is about this proactive duty, and the defence will be that you've taken all reasonable steps to prevent any sexual harassment from happening, and victimization. So somebody raising a complaint, and what you do about that, and that you're making sure you keep that member of staff safe, that people know how they make such complaints and how those will be dealt with, and there's a full investigation, for example, and that full notes are taken so that you have a reasonable steps defence should that ever arise that you need that. Lack of protection of volunteers, that came up during that consultation process, volunteers and interns as well, and actually the government has said they're not looking at that, they're not looking at changing the current law in relation to volunteers and interns, and they believe that interns are already covered as workers under the Equality Act, so they've not given them any further protection. And volunteers, they're saying that it would far outweigh the benefit of having volunteers if they then essentially it gave them the same cover as other staff. But what the government has said in relation to volunteers and interns is they expect them to be included within your policies on sexual harassment or anti-harassment policies in the workplace, so that they are covering all staff to make sure that everybody is protected. The next slide is a really fun slide about NI and tax increases. Going through these just very swiftly, April 2022, national insurance contributions and tax on dividends to increase by 1.25%, and the NIC rates will return to current levels in April 2023, when the new health and social care level will be introduced. The NIC increase will apply to class 1, so that's as it says there, employee and employer, and class 4, which is self-employed, both for the main and the higher rates, and the levy will be based on the national insurance contributions and apply to the same population and income, albeit extended to those above the state pension age of 66. flat rates for self-employed, so that's the class 2, and voluntary contributions will not increase, and existing NIC release for employers will continue to apply. The government also published a policy paper, including a plan for adult social care in England, containing commitment to develop and publish a white paper for reforming adult social care as well. Tax rises that place extra costs on employing staff and on the self-employed are never welcome. Introducing an NIC increase that is replaced by the levy may be particularly unwelcome, as the burden it places on businesses and businesses' systems provides time for HMRC to update its current systems. And on the next slide, my last slide, I think, flexible working. So we covered flexible working, we've covered the 8 reasons for refusal. The government consultation on flexible working essentially has ended up in looking at this area, so that a staff won't need 26-week service. They're essentially making it, or looking at making this a day one right for all employees in the workplace. They have said, which gives a little bit of comfort, that it's not a proposal to make flexible working an automatic right, because that would be an absolute nightmare for employers, and it will allow those 8 reasons, but they are looking at possible changes to those. So for example, you can only have one flexible application a year. They're looking at scrapping that, and having some sort of temporary flexible work, so doing that on a trial basis or for a certain amount of time. And what they're wanting to do is essentially, with this whole consultation on flexible working, they want to increase that communication, keep it going between employer and employee, and keep a constant conversation, because they believe that that's the best for both the staff that work and for the business itself, in order to create a happy workforce. That's a whistle-stop tour of what's going on, and over to Tom.
Thanks, Rebecca. I feel exhausted. so much has changed, so much is going on, isn't it? So hopefully the immigration law update is a little bit more sedate. I know lots of things have changed in your world, lots has changed in my world too, but hopefully we can summarize what's happened, and yeah, take a sort of fairly leisurely look at what's happening and what we're expected to happen over the next year or so. So if you should flick onto the next slide for me, please, Georgia. Oh, we've gone backwards, I think. There we go. So this is just a timeline, really, of what's happened to the immigration system over the last, well, nearly 2 years now. This is all, of course, brought about by Brexit, the government's plan, ambition for really ever since the Brexit referendum, to stop free movement of people from the EU, and as a result of that, they've had to make some changes to the immigration system. When I look down this list of changes, what strikes me really is generally how most categories really have had something of a sort of name change, or sort of minor makeover, rather than any substantive changes. The one exception to that is probably the skilled worker category, which we'll talk about in a bit more detail in a moment. But for the most part, these are sort of planned changes to existing immigration categories, and the introduction of a couple of new ones, which for the most part, so just try to sort of restructure things, and certainly from a lawyer's perspective, do make things a little bit easier to get your head around the restructuring of the immigration rules themselves. Just a couple of things to highlight before we move on to the changes to the skilled worker category. Obviously, the sort of key date within that timeline is the 1st of January 2021, the point at which free movement of persons from the European Union, European Economic Area, Switzerland stopped, and citizens from those countries started requiring immigration permission to come to the UK, rather than benefiting from free movement rules. We also had introduced on the 31st of January a brand new immigration category for Hong Kong residents who have within the family a British national overseas citizen, something which we'll talk about a little bit later, but something which is estimated to affect potentially up to 5.5 million residents of Hong Kong. And that visa is one which, compared with most UK immigration categories, relatively straightforward. So while we've dropped free movement for EU nationals, something akin to a sort of free movement immigration category has been introduced for citizens of Hong Kong, and I think the effects of that will be interesting to watch over the next few years. We had new rules on right to work checks coming into force on the 1st of July, so we'll talk about that in some more detail in a few moments. Also had a brand new immigration category for graduates. People who've been in the UK on a student visa now have a new immigration category they can switch into. And then something which has happened pretty recently and certainly wasn't planned, although some would say is perhaps an inevitable consequence of the end of free movement, are these short-term visa categories we've seen put in place for HGV drivers, poultry workers, and more recently pork butchers, and they've been introduced in a somewhat interesting fashion by taking the existing category for seasonal workers, which up until now has been used just for what's referred to as the edible horticultural sector, or fruit pickers to you and me, and expanding that to include those other sectors as well. And my next slide is a question for you, just to make sure that you're all still with me. And that's really related to that last point, which is whether in your particular sector, in your particular businesses, you've had any issues with recruitment. I've incorrectly marked that poll as multiple choice. If you could just tick one and let us know whether you have had any issues with recruitment which you suspected due to Brexit, and indicating whether that's for just lower skill vacancies, vacancies for senior roles in particular, or struggling at all levels, or maybe you haven't seen any impact on your recruitment. So if you could let us know, that'd be very interesting for us. Right, most of you not struggling at all. Maybe you're not recruiting. I should have perhaps put that as one of your options. But some are struggling at all levels. So that's interesting. Okay, thank you for that. So yeah, if we could move on to the next slide. So as I mentioned earlier, the main category, the category which I think is going to do the majority of the heavy lifting within the immigration system, as far as recruiters, employers are concerned, is this skilled worker category, which replaced Tier 2 General almost a year ago. And one of the key features of that category, and the reason why the government have had to, at sort of quite short notice, introduce these other categories for lower skilled workers, is that there is a minimum skills threshold for the category called skilled worker, which I suppose you would expect given the name. So that skill level is RQF level 3. That's reduced from RQF level 6. Those of you not familiar with the regulated qualifications framework, RQF level 3 is jobs which would, broadly speaking, require A levels, although you don't have to have those qualifications, but that's a sort of level of work that you're seen to be operating at. RQF level 6, on the other hand, would be a graduate level role. So obviously, by reducing the skill level, what we've done is we've opened up the skilled worker category to a far greater range of occupations than was available under the Tier 2 General category. Some other modifications, which certainly we would see as to be welcomed: the resident labour market test under Tier 2 General, where employers had to go through a pretty bureaucratic and prescriptive advertising exercise to demonstrate that nobody in the local workforce could do the job. That's been removed altogether. There are still requirements in relation to demonstrating that the job is genuine, that the vacancy is genuine, but you don't have to go through this sort of prescriptive advertising exercise that was previously required. Tier 2 General had a cap on the number of people who could come into the UK under that category every year. That cap's been removed, but the mechanism by which the cap was enforced, where you had a distinction between people from applying from overseas and people applying from in the UK, that's still in place. So if you are sponsoring under the skilled worker category, do bear in mind that it does make a difference which process you have to follow, depending on where the person you're looking to sponsor is applying from. Are they applying from within the UK, or are they applying for their visa from overseas? Another feature of the old system was that that ability to make an application in country was greatly hampered by your current immigration status, and that has been relaxed somewhat. Those of you familiar with your immigration categories might be aware, for example, that under the old rules, the youth mobility scheme, the old working holiday visa for certain nationalities, most notably Australians, New Zealanders, Canadians, was very restrictive in that once you'd been here for that 2-year period that visa allowed, you pretty much had to leave. And even if you'd found a great employer, a great job, and they wanted to keep you on, you would have to actually leave and apply for your visa from overseas. That's no longer the case. So now somebody under youth mobility can switch into the skilled worker category. And that was before we had COP26. So that is an environmentally friendly immigration policy that predates the current conversation about the environment. So that's certainly something to be welcomed from that point of view, if no other. All of these immigration categories are, according to the government, operating on a points-based system, points-based immigration system. For the most part, if you'll excuse the pun, those points are rather pointless. They don't actually afford any flexibility in terms of who qualifies. If you don't meet a particular requirement, you can make them up in another area by scoring high points under a certain criteria, for example. The only place that really kicks in is actually under the skilled worker category. So the headline minimum salary for most jobs is 26,500, but you can pay less than that if certain other criteria are satisfied. For example, if the job is on a shortage list, if the person applying is classed as a new entrant to the labour market under the definition of the immigration rules. So in certain circumstances, you can pay lower. So that's where that points requirement kicks in. And the one other thing to flag, which was always a pain under the old tier 2 general system, was that there was what was called a cooling off period. You could only spend a fixed period in the UK under that category, and if you didn't qualify for permanent residence, you'd have to leave and cool off for 12 months, and now those cooling off periods no longer apply, which certainly helps us out in some cases. Okay, if you can flick onto the next slide for me, please. Have we frozen? Here we go. So just to illustrate the point around the reduction in the skill level, and I have to apologise for the heading on the slide. That was 15-year-old me deciding to be a bit cool, and I've meant to change that, so that's embarrassing. Never mind. Anyway, so as I say, skill levels reduced from RQF level 6 to RQF level 3. This first part of the table just highlights the sorts of additional roles that we can sponsor under RQF level 3. So typically RQF level 6 would be sort of professional managerial grade roles. RQF levels 3 and 4 would include sort of middle management or sort of technical type roles. And then if you just flick on one more for me, Georgia, you can see I've also included some of the lower skilled roles as part of this table. Are we having some issues with the slides? There we go. So there are some, so the immigration rules set out the qualifying roles, but they do also include a table of lower skilled jobs that don't qualify. So if you're in a position where you're looking at sponsoring somebody in a role that could be described as lower skilled, do have a look at the descriptions of those lower skilled jobs as well, because if the job that you're looking to sponsor somebody to do is better described as being lower skilled, then you shouldn't be using the sponsorship system. You should be thinking of some other alternative. And the Home Office, that will probably be their main focus of compliance action in the future, is looking out for sponsors who have incorrectly described a job as higher skilled when it shouldn't qualify in the first place. Okay, if you could move on to the next slide for me. And this is a second poll. And really, I think this is just aimed at those who perhaps have some experience of the sponsorship system. So have you sponsored any roles at RQF levels 3 or 4? So jobs that wouldn't previously have qualified, but now do. So various options there. First one being, we don't have a skilled worker sponsor license, which I suspect applies to a few of you. And then no, we don't plan to sponsor anybody at that particular skill level. No, but we're thinking about it. Yes, we've done it just once, or no, we've started using it and we've done it on more than one occasion. So if you could let us know your experience there, please. No, we don't plan to. Okay, so yeah, quite a few of you saying you don't have a sponsor license. I thought that would probably be the case. But yeah, some of you have either looked into it or are thinking about it, or indeed have done it. So that's good to know. Thank you. Okay, yeah, if you could move on to the next slide then for me. So just to sort of quickly go through some of the other, highlight some of the other changes. The graduate route, as I said earlier, is one which a lot of employers might start to come across because international students in the UK previously had to find a sponsor. In most cases, would have had to have found a sponsor in order to stay in the UK. Now they don't. Now they can get a 2 or 3 year visa that allows them to take any job and effectively would have a sort of pathway into sponsored work. The category doesn't need to indefinite leave to remain, so it's not hugely desirable for students. A lot of them still will be looking for a skilled worker sponsor, but yeah, for those who are sort of struggling to find a job, that's certainly a useful option for them. The Hong Kong British National Overseas Visa I mentioned already, and as I say, yeah, might make some fairly significant changes to the labour market over the next few years if the number of people applying is as anticipated. Global talent is a category you may come across from time to time. Recent changes to that category included a sort of fast track application process for somebody who holds what's defined as a prestigious prize. And that includes an Oscar. So if you're in the entertainment sector, you may want to sponsor somebody who holds an Oscar or a BAFTA or some other prestigious arts prize. But there are also some prizes on there for in various academic disciplines as well. And the global talent category is a good one. If you qualify, it's aimed at what used to be referred to as the exceptionally talented, and allows work without any sponsorship requirements. And there are still sort of various other ways you can qualify even if you don't hold one of those particular prizes. Various categories remain unchanged. I won't go into those in too much detail. And the international sports person has had a bit of an overhaul in the last in the last couple of months, although that's fairly niche, so I won't go into too much detail on that one. And I mentioned the Youth Mobility Scheme earlier and sort of highlighted the sort of the main nationalities that qualify under that. I think it's next month, India and Iceland are being added to the list of countries. Those countries all countries on the Youth Mobility Scheme are subject to a quota. India, with its population of, oh gosh, what is it, about 1.5 billion, is only has access to 3,000 Youth Mobility Scheme visas per year. So there might be quite some demand for that from young Indian citizens over the coming years. Iceland, I think, has a population of about 300,000 and gets 1,000. So there's a sort of bit of a disconnect in the numbers there. All right, I'm going to move on to right to work checks, and I'll conscious of time, so I'll sort of go through this fairly swiftly. So for those of you not aware, 1st of July, the right to work guidance for employers changed. There's now a new list of acceptable documents. Unsurprisingly, documents associated with free movement, so EU passports, national identity cards, documents issued under the old EU free movement regulations are no longer acceptable for new employees. And they've included some additional documents, but for the most part, it's the same documents with the removal of EU national documents. It is now possible for someone who's applied under the EU settlement scheme, if they're still waiting for a decision on their application, if they present you with their certificate of application, that will stand as proof of their right to work, but you do need to check that with the employer checking service to check that they still have an extant application, and that permission or that authorization only lasts for a 6-week period. Sorry, 6-month period. And you may be aware that throughout the course of the pandemic, there have been what they refer to as adjusted right to work checking processes in place, where you can check right to work documents remotely. So someone can send you a scan of their passport and you can verify that via a video call rather than having to see the documents in the flesh, as it were. That's to continue until the 5th of April, and the government are looking at ways in which they can extend that more permanently. I think they're a bit concerned that it's not the most secure way of or sort of fraud-free way of checking documents. So they're looking at some way of extending remote checks but using some other secure method. Don't know what that's going to be. And just further on right to work checks, just to sort of say and highlight that, if you go on to the next slide for me, Georgia, it is far more likely now that you'll be starting to do right to work checks online, because the government's trajectory as far as the immigration system is concerned is to use their phrasing to make digital to make the immigration system what they're going to call digital by default. So everybody will have a digital immigration status. So instead of being issued with biometric residence permits or stamps in passports, everybody will have a digital status, and that's already started. So EU nationals applying under the EU settlement scheme will have for the most part, will have a digital status. You can EU nationals who've applied under the skilled worker or student categories, for example, will have a digital status. And then in addition to that, anybody who holds a biometric residence permit or a biometric residence card, you can actually they can actually share their status electronically, so you can carry out those checks online rather than having to see the physical document. So I think if it's not something you've done already, I would be amazed if it's not something you'll have to do at some point in the near future, because as I say, when you're that's the government's plan, is to make everybody is to grant all immigration status in a digital format. All right, just to finish off with, and again, gosh, we've only got a couple of minutes now for questions. Just to sort of talk about the forthcoming changes which we're anticipating. Most of this has been announced by the government, so could be fairly confident as to what's happened. They're looking to overhaul the existing sponsor management system. So, so we're going to see various upgrades around that. The Chancellor announced or gave further detail in the budget earlier last week around the new scale-up visa. So for businesses that are on a sort of on a growth plan, there will be a new immigration category available for them. We're expecting reforms to the intra-company transfer and global mobility route. So for international businesses looking to come into the UK, there's looks to be some reforms around that at some point next year. And then my big question mark is whether we might see further sector-specific concessions for lower skilled workers. And my feeling there is that those will be available to the sectors that are able to shout the loudest and garner the most negative headlines for the government, without getting too political about it. So that's my very brief update and prediction of what we've got coming up. And now we've got 5 minutes for questions, although I suspect we might be able to hang on for a bit longer after that if need be.
Tom, thank you very much indeed for that. And Georgia, could you just pop back to that last slide to get in touch on it? Just leave it up for another moment, please, because Georgia, sorry, it's just one of the questions we've got was somebody was asking about Rebecca, and I'm sure in due course Tom's contact details, Lewis said at the beginning, the slides will be shared, but they're the emails at the bottom, so if people would like to just jot those down now, if you'd like to get in touch with Rebecca or Tom in the coming days. Great, thank you very much indeed. Thanks, Georgia. That's great. Just to go back to the questions now. I've lost my questions under the chat. What's happened? Sorry about this. Chat. Here we go. Got it. Come up. Right. No. Georgia, if you're there, I'm struggling here. The chat seems to have got it finally. Sorry. Right, lovely. Sorry about that. Thanks so much. Okay. So thank you very much indeed. Sorry, I'll get back to speaking properly now. Tom and Rebecca, thank you so much for your great presentations there. Yes, we can go over a few minutes. It's not a big issue at all. I have to say, Tom, skills to pay the bills will stick in my head for some time now. So it's a good way of doing that. Right, let's get going with the questions then. First one from Ian Taylor. This is to Rebecca. Is not risk assessment for home working essential as well, and business needs to be aware of the cost implications of providing a correct working space?
So yes, it is essential, but you can ask your staff to carry out that risk assessment. So as long as you're posing the right questions, asking them about how they're working, where they're working, what they're working with, and there's all sorts of YouTube videos that you could be sending to staff, setting out where their desk screen should be, how it should fit, what the distance between their screen and them and their so that they can work that out, and you can ask them to carry that out. So yes. Sorry, what was the second half of the question? And the cost implications. Yes, absolutely. The cost implications are really important. So if it becomes disproportionate, then you're going to be making different decisions. But the size of the organisation and the financial resources available are going to be taken into account when looking at if you don't allow if that's for working from home, not allowing working from home.
Thank you very much indeed. I hope that answers your question, Ian. Michelle Mickelson, do you want to come in and ask your question about the health questionnaire?
Yeah, hi. If you've actually made an offer to a person, which is where you have done in the past, and you then send them a health questionnaire, can you include the question about are you vaccinated or not? It
depends. It's not really the answer that you want. I would say my first answer is probably no, because you're still then going back to why do you need that information? So if you need it because you're working in a sector where it's absolutely vital that you have that information, then yes, you can be asking for it, and you're having to go back to the reasons, which are, what is it in the substantial public interest that you know that information? If it's because other staff want to know or customers want to know, that's probably not going to be a good enough reason to put it on your medical questionnaire. Okay, thank you.
Thanks very much. Diana Lee, we've answered your question about the email address. I saw that. Julie, you said, I think the poll is skills led, and this is during Tom's presentation. Julie, do you want to come in and say a bit more about that and give Tom the opportunity to respond if you're still there?
I think it's just a comment about the lack of academic rigor applied to my question, which is fine.
Okay. I think Julie's left, actually, she hasn't come back. And Lee Charlie, it's quite a lengthy question there. We've got time. Do you want to come in and ask Tom direct? And if you're still there. No. Lee Charlie, no. Okay, Lee Charlie asks, how do you check a document remotely for a non-UK passport holder, e.g. an indefinite leave to remain issued many years ago, if cannot be done digitally?
Well, so under the adjusted right to work checking process that's been in place since near the start of the pandemic, as an employee, you can see you're allowed to accept a scan of a document that is on the right to work checklist that the employer has sent to you, and then you verify that remotely by them holding up the document in a video call. So in the same way as you would check a British passport. So they would send you a scan of the document and then you would check it over the video call. The one thing I would just urge a bit of caution over is that indefinite leave to remain issued in a expired passport isn't actually on the acceptable list of documents. So indefinite leave to remain used to be stamped in a passport, but they haven't been doing that for over 10 years. So the chances are it's in an expired passport, and where an indefinite leave to remain is in an expired document, it's not actually acceptable under the right to work checklist. So you probably should be asking them for something else.
Okay, thank you very much indeed, Lee. I think we haven't got any more questions yet. If I may, I've got just one for Rebecca, and that is if I've allowed flexible working for an employee and another employee has asked for the same working hours, but I can't accommodate both, what do I do? Can I refuse that? What's the answer?
So yeah, so you only have to consider a flexible working request at the point that it's made. So if you have accepted a flexible working request based on the needs of your business, and you've allowed somebody, say, to work 4 days a week and one day off, or whatever it might be, and then somebody else asks and you haven't got adequate cover to allow that, then I think that you've got a reasonable defence there if somebody brings a claim. And even if they have, I mean, obviously each one of their own facts, but even if there is a situation where somebody it's for childcare reasons, etc., but you genuinely cannot accommodate that request, then you're well within your right at the point that the request is made to be refusing based on one of the 8 reasons.
Great, thank you very much indeed. And while you've been talking, Julie Grimes has come back into the room. I think she's, like many of us, multitasking. Julie, are you still there? Do you want to quickly ask Tom, put your thoughts to Tom? Oh, she gone again. Still on call. Julie? Julia? Julie, sorry. Glasses. Julie?
I think she's saying that she's still on the client call.
Oh, I see. I thought she was still on this call. Okay, lovely. And what she said is, sorry, I'm still here. The point was, I think there's a shortage of my experiences, industry skills based. For example, IT and accountancy spring to mind immediately. So there we go.
Yeah.
Smashing. All right, brilliant. Well, look, thank you. We have just run a little bit over. To Rebecca and Tom, many thanks indeed. Also to Georgia for slides and everything else, and to you all for participating. It's been very, very informative and an awful lot of information there. So thank you very much indeed. I'll say once again to Rebecca Fox and Tom Brett Young, all the details from the slides we showed up there, and slides will be shared as we've said. Just a name check from Herts Chamber. We are largely going back to live events now, so which is one of the reasons many people join the chamber to network, etc. We've got the November Chamber lunch coming up. Bookings close on the 9th of November, and that's at Cromwell House. So all details on our website, all the details of all these on our websites. We have a virtual networking opportunity on Tuesday, 23rd of November. Christmas Chamber lunch at Chewinberry Farm Hotel has sold out, but can be added to a wait list. And then further advanced January Chamber lunch in 20th of January at Albury Park Hotel in Redbourne. And on the export side, we've got the DIT Export Academy follow-up 16th November and the Commonwealth webinar 30th of November as well. Just a quick name check from us. In 4 minutes past 11, not too bad. Rebecca and Tom, thank you so much again for your great expertise and knowledge. It's been really informative. And thank you to everybody again. And we'll see you all before too long, I hope. All right, stay safe and take care. Bye-bye.
Thanks very
Thanks
much.
all. Thank you.